Okay, I'm using a new microphone today, so hopefully this is really crystal clear. We have a short lesson here on the end of the Supreme Court, so grab a few cards, and I think there's four for this one. And we got a couple things we got to clean up, just some things that we haven't done yet, and then a couple of new ideas, a couple cards that we already know. So the first thing here is precedence, and that's really an important idea that I've mentioned in class. A precedent is when the Supreme Court makes a decision, and that decision becomes the basis of future decisions. So, for example, in the 1960s, a case called Griswold versus Connecticut, a person sued because Connecticut had a law against selling contraceptives. And then eventually that case was decided on the principle of the right to privacy. And then that became a precedent for future decisions, specifically on in Roe versus Wade for abortion. So a precedent is a case that's been decided. And then for the future, you use that same idea or principle. Okay, so backside. So a principle or rule established in a previous legal case. Go ahead and write that down. At any time, remember to pause it if I'm going too fast. Principle or rule established in a previous legal case. All right, I'm moving on, so you might want to pause. All right, and the idea here is that all inferior courts, courts below the Supreme Court, have to follow Supreme Court precedents. So precedents are set by the Supreme Court, and then every state, every court underneath it must follow it. Awesome. That's it for precedents. It's pretty easy. Okay, 2.63 restrictions on the Supreme Court. Now, this is really important. You have to know these because you need to be able to know what people will do if they disagree with a Supreme Court decision. So the things that I list here are often going to be your Part C on a Supreme Court essay. So make sure you know this list really well. You're going to have to stop and pause and study it after we're done. Okay, here we go. First, how do you stop a Supreme Court decision if you don't like it? What restrictions can be placed on it? First off, congressional legislation to modify the impact. And that just means modify means to change it slightly. So Congress passes a law, or the Supreme Court rules deems some action constitutional or unconstitutional, and then Congress doesn't like that decision. So it changes the law a little bit. So for an example here, the picture, you see the guy, these two guys burning the American flag. So there's a famous case in the 80s, Texas versus Johnson, that ended up in the Supreme Court in 89. And a guy burned an American flag and was arrested and punished for it in Texas. And the guy sued, and he said that it was right to free speech. So it ends up going to free Supreme Court, and the Supreme Court ruled in favor of the guy who burned the flag, that indeed it is free speech to burn the flag. It's symbolic speech, and so therefore they couldn't punish him. Well, states and localities changed the way they modified the law. In order, they made legislation to modify the impact. Is they then set up all kinds of rules about getting permits in order to be able to burn something publicly. And of course, a lot of people that are burning American flags, they don't even know that. So then they just go out and they burn it without a burning permit. And then they get in trouble for not having a burn permit. So that's like an example of like modifying the impact by changing the law a little bit differently. Okay, that's one way. Second way is constitutional amendments. This is the most common way, probably, of changing a constitution. You can always answer this. Like if the question says, like, what could you do to modify the impact? Push for a constitutional amendment. A president could propose a constitutional amendment and hope Congress takes it up. A individual can press for a amendment and elect Congress people that will support a constitutional amendment. So you can always argue constitutional amendment is an option. I'll give you some historic examples. The 11th Amendment changed some court jurisdiction. It allowed the it got rid of the ability of you as an individual to sue another state. You used to be able to do that. Now you can't. Why? 11th Amendment. This is because of a Supreme Court decision in the 1790s. The 14th Amendment. It protected African Americans. And by the way, you don't have to necessarily write these down. That's protected African Americans. And here's what the why it did this, because the Dred Scott in 1858 case said that blacks for more than a century have been regarded as an inferior order and altogether unfit to associate with the white race, either in social or political relations, and so far inferior that they had no rights which the white man was bound to respect. So this horrible decision, Dred Scott, which by the way helped lead to the Civil War because the North was outraged by it, they then passed, the Republicans in the Congress are going to pass a constitutional amendment, the 14th Amendment, which overturns the Dred Scott case. And the 14th Amendment says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. So that's an example of how you can modify a Supreme Court decision. Um, 16th Amendment, there was a Supreme Court case that ruled the income tax in the 1890s was unconstitutional. And so they passed the 16th Amendment to make it constitutional. The 19th Amendment, women's right to vote, although states could allow women to vote, and many of them did, about half of them did. Um, this still, um, they still passed the 19th Amendment because it forced any state that didn't allow the women to vote, it forced them to. So many of those states were southern states. So good examples there. All right. Another thing you could do to change the Supreme Court decisions: future judicial appointments and confirmations. Future judicial appointments and confirmations. So president wants to change a case, then when he gets a chance, he can change judicial appointments. And then the Senate side of things, a Senate can confirm judges that they agree with. So you're appointing judges that have the same philosophy as you, maybe activist or restraintist. So that's the second part of this. Please write what's in parentheses. So ideology shifts from activism versus restraint. And we talked about how activism is generally more associated with Democrat presidents and restraint more with Republicans. So an example here, and I actually have this as a point coming up, the public can vote for presidents and senators who will impact the future court ideology. And so you can vote for people based on the Supreme Court. And there are people, by the way, who like when they vote, like one of their number one things is thinking about the courts. All right, moving on. Um, President and states evading and ignoring decisions. This has actually happened. Andrew Jackson, the left, ignored the Cherokee case and told Justice Marshall, if he wants to stop me from removing the Cherokees, let him enforce his own decision. And he just totally ignored it. And he moved the Cherokees anyway. Abraham Lincoln in the Civil War actually arrested some people that they were helping to try to turn Maryland to the Confederacy. He arrested him, threw him in jail. Supreme Court said, you can't keep that guy in jail. And Abraham Lincoln just literally ignored it and kept him in jail to the end of the war. So these things have happened. Of course, another infamous case was civil rights. The Arkansas, Little Rock, Arkansas, the governor said, I am not enforcing desegregation policies by the Supreme Court. And so the states just totally ignored it. And then President Eisenhower sent in the 101st Airborne, and the black students were given an escort to school. And then legislation changing court jurisdiction. So if the court doesn't, if the Congress doesn't like the court ruling on a certain issue, they could actually pass a law saying that in the future the court can't rule on that type of issue. And then lastly, and this is something I mentioned earlier, but I'll put here as a point. Remember, people, citizens, interest groups, whatever you want to call it, you vote for presidents and senators who confirm judges you want, or for president appoint, senators confirm. So you're looking for judges that you want. So there you go. So those are all things, and this is a really important card, things that you can do to restrain the Supreme Court, because remember, they've served for life, so we can throw them out of office in the next election. You have to have another way, and these are the ways. Okay, 2.64, legitimacy of the Supreme Court. And what we mean by legitimacy, it's like how, like we believe in it. Like the legitimacy means like it's something we believe in, something that we can all have faith in. And there are some reasons why people kind of question whether the Supreme Court should get to do what it does in terms of ruling the big rulings that it has. And here's why. One is that the court has made very controversial and unpopular decisions that make the court question the court's legitimacy. Like, who's the Supreme Court to make these very controversial decisions? They're unelected and they serve for life. And therefore, some people think that maybe it's better if the people get their way. And those things cut both ways. They cut on liberal, they cut on the conservative side. Liberals, for the most part, hate the Citizens United decision from 2010, and conservatives, generally speaking, aren't real big fans of Roe versus Wade. So both sides have their issues with the Supreme Court making controversial and unpopular decisions. A second thing that's just real clear is that life tenure plus the ability to rule laws unconstitutional means that there's almost no accountability. There's no accountability for Supreme Court justices. Like, what can you do? Vote them out the next time? Oh, no, you can't. So they have a lot of power. And so people kind of question whether that's right. That question, that questioning that is like questioning their legitimacy. And then lastly, and this kind of wraps into the last card, is that the Congress and the president can only change with future appointments, amendments, changing jurisdiction, or refusing to implement decision. It's pretty much the only things that Congress and the president can do because these people serve for life, and some of them serve for 30 plus years. So that's an issue. Okay, I'm moving on to the next one. So if you want to pause it, you can go ahead and do that. Okay, these are the last two things here are things we've already done. I just want to make sure you have a card on it so you have something to study back, 2 months from now, right before an AP test, and you're studying, you've got these just to remind yourself. So, okay, appellate. I should have done this earlier in the unit, by the way. Appellate, we already know what that means. It's an appeals court. It's an appeals court. It reviews cases. That's it. It reviews them. It doesn't hear a trial. So it's not a trial court. And lastly, one thing to remember, a little tie in here with some earlier content that I might not have made clear when I talked about appeals courts, but groups send amicus curiae to these briefs to the courts. So if you're an interest group or you're an expert in something, then you can send an amicus curiae to the court in order to try to influence them. Or you can use a precedent from a previous court to try to influence a case in the future. So groups can send that. Okay, good. Done with that one. All right, put it aside. Okay, and the last thing for this lesson is 2.66, a writ of certiorari. Again, something we already know. Everybody should know this now, but just in case in 2 months you forget, because that's what happens, let's just have a card, backside flip. It's called a cert. That's the classic writ of cert. And it's the decision of an appellate court, specifically SCOTUS, to review a case. Decision of an appellate court, specifically SCOTUS, to review a case. And of course, the rule of four applies. If four judges say yes, a writ is granted. If four judges say yes, a writ is granted. All right, awesome. That's the entire thing. Now, here's the thing. You need to study these cards. You need to study the Supreme Court cards for a few minutes, and then you have a quiz on this. So make sure you study first before you take that quiz. Thank you.